18.
18.
On the last occasion, I was given 3 weeks time to file my reply affidavit, but it's almost ready. Maybe given some time, my lord.
That stone crusher.
Yes, Stone Crusher.
On the prayer of Mr. T. Counsel for the petitioner. Praise for and is granted another further 3 weeks time to file affidavit in reply.
Interim order may be continued.
Interim order was the dates.
Obliged, Lordship.
Wait, Mr.
Yes.
Wait to mention item number 31, my lord, I seek some more time to seek instructions. Sentence has now been completed.
Okay.
I have not been able to get in touch with the this person.
Mr. Deepak Counsel for the appellant submits that he may be granted further time to obtain instruction. Earlier also we have granted further time to obtain instruction as the sentence by the learned court below has already been completed by now. Mr. However, as on that he has he could not contact with the appellant. Considering about that this matter will be listed after 4 weeks. So as to enable the counsel for the appellant to obtain instruction.
Okay.
My
Yes.
lord, may I, my lord? My lord, item number 10, my lord. I would like
10.
to mention- Yes, my lord. The
Yes.
leading counsel, Mr. J. Gini, my lord, due to some personal difficulty, he could not appear today. So,
Mr. B. Picha, learned counsel for the learned counsel appearing on behalf of Mr. J. Gini, learned counsel for the petitioner. Submits that Mr. J. Gini, learned counsel has some personal difficulties today, for which he prays for listing the matter
on 16, my lord. 16, next week, no, 16.
after 2 weeks.
My lord, item number 20 also, my lord. Same. 20.
Same order.
Yes, ma'am. My lord, this item number 12, my lord.
J. Gini.
No, this DK Diori, my lord. He is also having some personal difficulties, so he has requested me to take adjournment
On the prayer of Mr. So-and-so, learned counsel.
after 3 weeks.
DK, learned counsel for the petitioner. Place this matter after 3 weeks.
My lord. My lord, and item 14 and 15, my lord. This matter may be fixed on 23 September, my lord.
Why?
I am the local counsel here.
Ah,
So, my lord, the engaged counsel is
on the
outstanding.
prayer of Mr. B. Picha, learned counsel for the petitioner. List this matter after 2 weeks.
Fixed date, my lord, 23 September.
2 weeks.
My lord. Obliged.
My lord, I beg to mention item number 13.
13.
Yes,
1 3.
yes.
Okay.
The learned counsel is out of
On the
station.
prayer of so-and-so, learned counsel for. Your name is there.
No,
Learned counsel appearing on behalf of Mr. C.W. Mantau. Learned counsel for the place. List this matter after 4 weeks. Next.
Your Lordship, I would like to mention item number 19 on
Yes.
behalf of Mr. Gautam Phukan.
Yes.
Due to the death of his maternal uncle, he's unable to come today. So he has asked to, he has requested for 2 weeks' time.
Ms. M.S. so-and-so, learned counsel appearing on behalf of Mr. G. Phukan, learned counsel for the applicant. Press for and granted. 2 weeks.
2 weeks.
2 weeks. List after 2 weeks.
Obliged.
Granted 2 weeks time to for listing the matter. List after list after not list after 2 weeks.
Lordship, I would like to mention item number 29 and 30
29 and 30.
on behalf of the standing counsel, Mr. U. Dekar,
What's
for
wrong?
the petitioner.
Yes. Who is for Clement?
Yes, I am for the petitioner.
Yes, who is for Clement?
Lordship, consent has been taken.
Have you received the
For item number 30,
Compensation.
consent has been,
29 and 30.
for item 30, consent has been taken.
On the prayer of so-and-so, learned counsel appearing on behalf of
Also, item number
Mr.
32.
Utica, learned counsel for the petition. The learned counsel will appellate. List the matter after 2 weeks. 2 weeks,
Item number 32.
29 and 30. 2 weeks. 30 also, it's listed together.
Yes,
Hmm.
and item number 32 also.
32,
Yes.
same order.
Obliged.
Obliged, ma'am.
Yes.
Number one.
Yes.
I'm challenging the summon issued by the interpellate council.
Hmm.
Here in this case, lawsuit, this matter is pending before place council.
Hmm.
For lawsuit, first lawsuit, annexure
Of which village?
place farming club.
Ah. All you are from same village.
Yes, lawsuit. We are from the same place. Because of this lawsuit, someone was issued by the place council's farming club lawsuit.
Hmm.
Lawsuit may kindly annexures 3 lawsuit, page 20 lawsuit.
Hmm.
And lawsuit translation copy.
Page 21.
Yes, lawsuit, page 21 lawsuit.
Hmm.
May I read lawsuit?
Bamin Bilad village.
Yes, lawsuit.
Yes, then.
And the complaint made by the private respondent lawsuit.
Hmm.
And now lawsuit, impugn order is annexure 5 lawsuit. Impugn someone.
Yes.
5 copy.
This is by whom?
This by lawsuit, Inter-Village Council lawsuit, Bangong Kaba,
Yes.
Inter-Village Territory Council lawsuit.
Hmm.
So I am agreed by this order lawsuit.
Why?
This impugn lawsuit, Kaba is their lawsuit. This is appellate authority lawsuit.
Hmm.
This is appellate authority as per lawsuit section 24 of FR lawsuit after the amendment of 2023 Act lawsuit. 23 lawsuit.
Bilat and Bamin are same village.
Same place, but
Same
this is,
villages.
yes, lawsuit. This is villages lawsuit. Bamin,
Okay.
Bilat is village lawsuit. Lawsuit,
So you are agreed by this.
Yes,
Page
lord.
27.
yes, lawsuit. This is
Urge Mr. G. Bamlan counsel for the petition by filing this revision petition, by filing this petition. The petitioner is stated to have agreed by the Kebang summons dated 17/07/2024 issued by the Gawabura, a president
secretary jointly lawsuit.
president and secretary,
Bangong,
Bilat Circle, Bangong, Kebang,
yes, lawsuit. From Inter-Village Territory Customary Court, Bilat Circle.
come into village territorial customary court, Bilat Circle. On the ground that since the petitioner and the respondents, as the petitioner and respondents are from the village, are from Bilat Bamin village, and the dispute is pending before the said Bilat Bamin village authority, the secretary and president of secretary and president of Bango Kebang come inter-village territorial customary court, village circle has no authority. More particularly, authority, Mr. The Mr. Issue notice returnable by 4 weeks. Now, the counsel for the petitioner shall take steps of service of notice upon respondent, sole respondent within 3 days from today. Register post with AD so and so later, huh? Next parent. Considering that the disputes between the parties are pending before the village authority of Bamin Bilad. What is this? Bilad Bamin,
Yes, Lordship.
Bilad dash Bamin village. What's this? Considering that the village authority of Bilad Bamin village, coupled with the fact that the Bango level kebab, what is it? Bango?
Yes, Lordship. Bango, Gabang,
Bango kebab come into village territorial customary court,
Bilal Circle.
village circle, is an appellate customary court in terms of the
In terms of
Civil
section
Code.
24 of
section 24 of
FR,
uh,
Assam Frontier Regulation Act.
Arunachal Pradesh, huh?
Assam Frontier Regulation Act, 1945. Lordship.
No.
After amendment. Lordship.
Amendment.
Here is the,
Let's see, amendment.
yes, Lordship. Section 24. Lordship.
Okay. As per section 24 of Assam
This is the Lordship.
Frontier Administration of Justice with bracket close, huh? Assam Frontier within bracket Administration of Justice within bracket Regulation within bracket Amendment Act 2023. What I'm saying? Couple of defect, huh? Twenty-four of, comma, till returnable that the impugned summon order that is 17/7/2024 shall remain suspended. This after 4 weeks. Same issue,
No, man. New act, new offense, new act,
new offense,
new act.
no issue.
No issues.
Yes. I have filed this anticipatory bail application under 482.
Call for the case there, it's, what is this? POCSO.
Yes, Your Honor. Age of the applicant, victim age is 12 years.
12 years.
Yes. But my lord, I am a driver by profession working
It's okay.
under,
But the guarantee that you may not have committed. If
You
you are a
know-
driver.
I just want to read the content of affairs, so is to let this.
No, we'll see.
To interfere.
We'll fix it, sort that. We'll take it up next week. Can you?
Oh.
Get ready.
Otherwise, because,
Yes.
yes,
Where was the FIR?
FIR can we see page number 14?
14.
Yes, page 14. Subject, the first information report against Mr. So-and-so for committing sexual assault upon my minor daughter, Miss So-and-so, on 30/7/2024 in the residence of late Mr. So-and-so at Silly Village. With all humility and due regards for rule of law, I am submitting this instant FIR with interest to set the legitimate affairs into motion amidst my grievances moment. My grievances is as follows. I am the mother of a minor Miss So-and-so aged about 11 years old, and I am making this instant information in her behest interest as a mother and a natural guardian. Number two, my said daughter and I were present in the residence of late Yunkar Kampu on 37/24 since morning for the dead anniversary of late Yunkar Kampu. There were also several other relatives and loved ones of late Kamku present for the death anniversary. My daughter was playing in the compound field near the auto, which was parked during around evening time. She was playing with a toddler girl, Miss So-and-so, at that time. I was sitting with several other guests at that time under the same compound, but a little far from where my daughter was playing.
Why,
at the-
482 of Bharatiya Nagrik Suraksha Sanhita 2023. Come on, the applicant has prayed for grant of privilege of prayer spell to the accused applicant in connection with Likabali PS case number 19 of 2021 under section 75 within bracket 2 bracket close of Bharatiya Naya Sanhita 2023, read with section 10 of POCSO Act. Call for the case diary.
And my lord, notice to respondent number 2, the complainant.
Mr. J. Lanet. For the PP, appears for the state. So, Mr. The land council for the applicant shall take a step for service of notice of respondent number 2. Respondent number 2, the informant, the informant within 2 days. By registered court as well as Dusty.
Yes, sir.
Dusty also, Dusty mode.
Rotate through the office of PP, since this is a POCSO case.
Okay, rotate through the office of the public prosecutor.
Alright.
List. When?
16.
16.
It will be too late, my lord, because I am a service holder.
The case diary has to come also.
The notice has to
That
go.
14.
14.
14.
To amicus, my lord, they would be submitting.
We'll take up this 5 and 6 bail application. Continue. I mean, first, as a leading case. 5 and 6. Yes. Five and 6. Just wait. We'll ask him. Yes. 5 and 6, not this one. Yes, Mr. 5 and 6. Yes. It's the same, arises out of same FIR.
Yes,
Yes. We'll hear him first. Not on merit. Item 5 and 6. Yes. Yes, why 438?
Lordship, the reason for invoking 438 is that this offense, Lordship. This offense was committed in the year 2021. It was registered under the Penal Code, Your Honor, IPC. Now, if my lord will see the saving clause of BNS, Lordship,
Yes.
the act which has repealed IPC, herein, my lord, section 358 in subclause E provides, if I may read, my lord,
Where is the BNS? Subclause E.
of 358 BNS.
358.
358. That is the saving clause inserted into the BNS.
Yes.
Lordship, the Indian Penal Code is hereby repealed. Notwithstanding the repeal of the code referred in subsection 1, it shall not affect
BNS, sorry. BNS.
BNS.
Aye, aye.
Section, clause E,
358.
358, clause E, my lord. Notwithstanding the repeal of the code referred to in subsection 1, it shall not effect any proceeding, investigation, or remedy in respect of any such penalty or punishment as aforesaid, and any such proceeding or remedy may be instituted, continued, or enforced, and any such penalty may be imposed as if the code had not been repealed. If my lord will kindly notice, my lord, it also speaks about institution, continued, and enforced, lordship. If institution is taken into account, lordship, it means that even something new can be instituted even after 1st of July 2024, lordship, in accordance to IPC.
It said any proceeding, investigation, or remedy,
Yes, Lord.
remedy in respect of any such penalty or punishment.
Yes, lordship. Now, lordship, IPC does not provide for any remedy, lordship. It is only offenses that are described in the penal code, lordship. Remedy, in my understanding, remedy will be appeals.
Is it an remedy you are seeking against the penalty or punishment?
A penalty of arrest, lordship. I have been arrested
What
in
do you mean by penalty of arrest?
I have been,
Sorry,
my lord, if I may.
we are concerned
Yes, lordship. Oh, my lord, remedy is
of a
also
bail
there.
application, under which provision you have to, you ought to file the bail application. According
Under the-
to you,
Yes, lord.
it is 438
438.
because there is a saving clause
Yes, lord.
under BNS.
BNS and one more section is there in under BNSS, lordship. Because it speaks about lordship. If against an offense I'm arrested, my remedy is bail, lordship, and that will be governed by the procedure.
Remedy against the penalty and the punishment.
So, penalty.
What do you mean by penalty and punishment?
Lordship, penalty being something I am imprisonment is penalty, fine is also penalty, arrest is also, I believe.
We'll just say, heard Mr. So and so.
Lordship, if I may,
Counsel for the
section 4 only of BNSS,
applicant.
lordship.
In both the bail application, I think 5 and 6. Well, I'll just record your facts. The applicant, accused applicants have filed the application, the present application under section 438 of the Code of Criminal Procedure, 1973, within bracket, now repealed, bracket clause, for grant of privilege of pre-arrest bail to the accused applicant in connection with the crime branch PS case number 13 of 2021 under section so and so of IPC. When it was registered,
Lordship, in November of 2021.
which date?
November 2021.
Registered on 26/11/2021. Mr. So-and-so, the constable deputy accused applicants has submitted that in view of the section 358, section 358, in view of the repeal and savings sections under 358 of BNS 2023, particularly section 53(8) within bracket 2, bracket close, bracket small e, bracket close, read with section 531 two within bracket two bracket close bracket small a of BNSS 2023. The present applications are filed under the old act, under the old act, under section 438 of Code of Criminal Procedure, 1973. Now repeat bracket close. According to him, which is maintainable. Yes.
Lordship, I believe I have not been clearer. Lordship, I believe I have not been clearer. The purpose for this referring to section 358 was that investigation can be instituted even after 1st of July. Now, 358 is that. Now, even in the BNSS, there is a section 4, subclause 1.
What do you say?
I have referred to this section 358 because to substantiate my argument that even after 1st of July, an investigation can be instituted under IPC sections if the offense was committed before 1st of July. Now, the other part of the argument being section 4 of BNSS, Lordship. Now, section 4 of the BNSS talks about trial that will be governed by the BNSS. Now, like in the
He further submits that as per in view of the section 4 of BNSS 2023. Since the trial has to be
in
accordance with the
section 4 speaks that the offenses under BNS will be governed by BNSS. Now, this section is exactly like section 4 of the old act, wherein under CRPC.
According to so and so, he further submits that section 4 provides that the offense under BNS shall be governed by
BNSS, Lordship.
BNSS.
Yes, Lordship.
BNS Act.
BNSS. The new procedure.
Which is very material with the section 4 of
the old CRPC 1973.
CRPC. Section 4 of CRPC 1973. Therefore, the petitions, they please do. The offense, the FIR was registered on 26/11/2021, and under section so and so, 153, page 2, 153, 1 so and so, all this section, Indian Penal Code. Before coming into force of the BNS and BNSS 2023, the bail application is filed under section 438 of CRPC. Now repeat, which is maintainable. That's all. You are relying some judgment.
Lordship, judgments are not
Relying.
No,
You are
Lordship,
not
only
relying.
the 2 judgments are there, but my lord is differing from those.
Yes, relied judgment of the Honorable High Court of Rajasthan. What is that? High Court of Rajasthan dated 09/07/2024. In the case of Christian Joshi versus State of Rajasthan. In CRLMP /4285/2024. And the order of the coordinate bench of this court dated 19/07/2024. In the case of Sanjit Kaur versus State of Arunachal Pradesh in AB 102 of 2024. wherein while relying on the saving clause under section 531 within bracket 2 bracket close bracket small a bracket close and 358 of BNS S 2023. The Rajasthan of the Honorable Court, Rajasthan High Court and the Government Bench of this court has held that since the FIR was registered prior to the enforcement of the BNS 2024. The and view of the saving clause under section so and so 531 so and so so and so. The petition. The application, the petition shall be filed under section 438 of CRPC, 1970. Yes, that is the issue.
Yes, my lord.
Next.
Yes.
That's all. Next. Then. Whatever you.
My lord, my simple understanding in this case, my lord, the settled rule of construction is that if the words of a statute are plain, clear and unambiguous, then the courts are bound to give an effect to those meaning irrespective of consequences. Well, now if I peruse the repeal and saving part, my lord, I don't find any ambiguity in respect of the proceeding which is pending
Therefore,
in respect of the new
therefore,
application.
accordingly, it should be under
482.
482.
Yes, my lord.
Next para. Mr. J. Sri learned public prosecutor before the states. While opposing the present application, bail application filed under section 438 CRPC is in bracket. And has submitted that in view of the clear and unambiguous provisions provided under the saving repeal and saving clause under section 438, 431.
Yes.
Within bracket 2, bracket close 2, bracket close, bracket small a of BNSS 2023. The applications, the well applications ought to be filed under the provision of new act, i.e. that is section 482 of BNSS Act 2023. After coming into force of the BNSS 2023, even though the FIR was registered prior to the coming into force, and the offense charge is under IPC. Please stop. And he further submits that the provisions, the saving, the provisions provides, the provisions only saves the pending application, inquiry, investigation, appeal, etc. Mr. Since the present petition has admittedly been filed on when it was filed 26/07/2024. That is after coming into force of the BNSS 2023. The petition, the application would lie under the provision of new act, i.e. section 482 of BNSS 2023. Accordingly, he submits that, therefore he submits that the petitioners, the applications are to be either treated, should be filed under the new act, or maybe treated as under the new act.
This, my lord, short judgment in respect of the golden rule of construction, my lord, only for interpretation, my lord.
Mr. Yes, learned counsel for the petition, the learned public prosecutor has relied on the judgment of the Honorable Supreme Court. In the case of
Gurudev Datta,
BKSS Maryadit and others versus State of Maharashtra.
relying on para 24, reported in 2001 for SCC 534.
2001 for SCC 534. Para
24, my lord.
24. Yes, para 24. Para 24, huh? 24. Yes.
Two amicus in this case.
Huh?
We have two amicus in this case.
Just wait, just wait. We'll hear you. Then we'll come to the next revision petition. We'll hear them first, why they have filed and why they have not. Then this is AB, huh? This finished. 3 and 4. 3 and 4. 3. Item 3. Yes. Parvinder Singh. Yes.
4, 3.
Mr.
P. Gogoi.
P. Gogoi, learned counsel. Heard Mr. No. Mr. P. Gogoi, learned counsel, appearing in the criminal petition 112 of 2024. Has filed some no, don't wait. The criminal petition so and so is filed under section 528 of BNSS 2022. Read with section 438 of 438/442 of BNSS 22. For quashment of complaint /NI case number 02 of 2024. Under section 138.
138, Lordship.
138 of NI Act. Pending before the
Chief Judicial Magistrate.
Chief Judicial Magistrate
Pasigar.
which was registered on when it was registered.
Mr. Lordship, the first order, Lordship, 23/2024 is in
23?
23/2024.
23.
Cognizance was taken.
23?
20 March 2024.
2003 2023.
Or Lordship.
2024. Mr. According to Mr. So-and-so, learned counsel for the petitioner. Since the BNSS 23 has come into force with effect from 01/07/2024, the application is being filed under section 528 of BNSS 2023, though the case was registered prior to the coming into force of the BNSS 2023. Okay, we'll consider.
Lordship, the matter may be fixed on next.
Yes, we are considering the legal issue. I'm just recording your submission and the facts of the matter because you are taking over. Yes, what do you say? No, nothing.
Yes.
According to you,
Uh,
you cannot have a different view other than the PP. Otherwise, we deal the conflict. That has to be referred to the
I have some.
Home Department.
I have some view here also. I realize.
Same view.
Yes, I realize some.
Then-
My lord, item 4, my lord, though my views might differ, my lord,
Yes.
but as the coordinate bench has passed an order, my lord, that the old act will apply. So to avoid the technicality, we have filed this under
In
439.
Item
4, lord.
item 4, huh?
Though my views differ, my lord.
The item for bill
Four.
application, 78. This petition, the bill application is filed
Under
under
439.
section 439
Yeah, CRPC.
CRPC. In view of the for the release of the accused, namely,
But
same,
yes, lord.
Srimati Pate Reni,
Yes.
in connection with,
Pate ya kya? Pate ya kya?
uh,
Accused is pate ya kya?
Pate Yaki.
Yes,
huh,
pate ya kya.
In connection with collision PS case number
10 of 24.
10 of 2024 under section 302 of IPC. This was registered on?
This application, lordship. This
No. This
this
was
25
the
2024.
FIR was registered on 25
2024.
2005
Yes.
2024.
Yes.
2024.
Yes.
Yes. And the bail application has been filed
On 18th of July, lord.
18/08/2024. After coming into force of the new BNSS 2023. Mr. Peter, let me consider the applicant has submits that. So, since the coordinate bench of
Yes,
this court, in the case of
Sanjit Kaur. Sanjit Kaur versus
in
State
the
of
case
April.
of Sanjeev Kaur versus
State of April.
Sanjeev Kaur versus State of April, so and so. In AB 102, 2024. Whoever the coordinate bench of this court has held that if the offense, if the FIR is registered under before coming into force
Yes, lord.
of the BNSS 2023 under the provision of under the and this and under various sections of and if under and the offense is charged under section under the provision of IPC, the bail application would be filed under section 438 of CRPC 1973 in view of the saving clause under section 431 2A of BNSS 2023.
431.
Mr. However, he,
531, I suppose.
what, 531?
Yes.
However, he submits that in his considered view, even if the FIR is registered,
Yeah.
and the offense are being charged under IPC, and prior to the coming into force of the BNSS
Yes.
2023, the provisions of the BNSS would
Yes,
apply.
in application, new applications. Obliged.
Then 7 and 8(7). This is 482.
Yes, sir.
This is so and so is the 133, 2024 is filed under section 482 of CRPC, 1973.
Here,
For
sorry to,
enforcement of GR case number 43 of 2023, pending before the Chief Judicial Magistrate. The 43 of 2023, under section 380 of IPC, read with section 3 of PDPP Act, pending before the Chief Judicial Magistrate, Capital Complex UPR. In view of the order of this, according to the order of the coordinated bench of this court in so and so, same Sanjeev Kaur, so and so, so and so. It's okay.
here, your lordship, some peculiar circumstances there. Because that offense was committed prior to coming in force of the this BNSS.
Then you continue. The
And-
application has been filed. The petition is filed on 30/07/2024 after coming into force. Although the case was registered prior to that. Mr. G. Tado, additional PP.
Not registered prior, registered after the coming into force.
When it was,
What I attempt to point
when
out,
it was registered,
Your,
how can this be?
yes, your 31/7, after
Yeah.
the commencement of the 31/7.
Case was registered.
No, lordship, case was registered on 16/1/2023.
Yes.
yes,
Your is application is 38 after coming into, but case was registered.
and this 482 was invoked on the basis of settlement agreement, which arrives on the
No, we're concerned about the date of filing.
19/7.
Yes. 8. Criminal
This criminal petition has been filed for quashing of
115. So it's under section
under section 528 of BNSS. Read with section-
528 of BNSS 2023. For quashment
Yes, Your Honor.
of orders dated 12/12/2023, 23/02/2024. 084/2024, 03/05/24 passed by the Special Judge NDPS, West Coming, East Coming, and Tawang at Bombilla. This is by whom?
The bail, Your Honor?
You're against the release of the accused, or are you?
I'm asking for releasing the accused person on previous bail, Your Honor. The bail initially was granted by this honorable court on 31st/10/2022. However, by issuance of non-bailable arrest warrant by the Special Judge NDPS Bombilla, he was arrested. So the submission of the petitioner is that he was
Whereby the-
arrested without cancellation of bail.
Bail, non-bailable warrant of arrest is under challenge. Order of non-bailable warrant is under challenge. The application was filed on. The present application is filed on. When it was filed? 06/08/2020. Under the new act. Any submission? Why you have filed under the new act, provision of new act?
Your Honor, in my humble opinion, according to the repeal section, that is section 531 of the BNSS Act, the criminal procedure code has already been repealed. And only in the cases which were already pending before 1st of July 2024, only in those cases CRPC will be applicable. So since this is a new application, in my humble opinion,
MS TOI Bhutia, learned counsel for the petitioner, semester. The present application has been filed under the new provision of BNSS 2023. As the all acts has been repealed. And only by saving only the pending applications.
Yes.
Under section 431A so and so, 2N
531.
of so and so, so and so. That's all.
deeply obliged.
Then
Yes, Your Lordship. Lordship, I'm on Sanjitkar case, Your Lordship. According to my submission, Your Lordship, here, the bail was initially granted by this honorable court under section 439. And without cancelling the same, the learned court below has cancelled the bail. They have challenging that impugn order. But this matter is on the inquiry stage. And the inquiry is pending. If inquiry is carried out under CRPC, any application arising out of the main proceeding will have to be governed by the CRPC, because the saving clause say the pending proceedings, Your Lordship. So if any application arising out of that pending proceeding, that has to be governed by the CRPC. That's it.
Mr. T at the learned additional PP, learned appearing for the state. While opposing the application under the provision of section 528 of PNSS 2022, being not maintainable, submits that since the challenge is the order of non-bailable of
warrant, yes, Your Lordship.
non-bailable warrant of arrest by the London trial court. And the inquiry and the
The inquiry stage, wherein without cancelling the previous bail order passed by this honorable court, NBW has been issued.
without there being any cancellation of the
Bail order.
bail order, bail
Bail bond may be, Your Lordship.
bail order bail order passed by this court,
This honorable court.
passed by this court is under challenge.
Under challenge.
Under challenge.
Your Lordship, that was not, yes, this NBW was challenged, yes, Your Lordship.
As the inquiry,
Yes, inquiry stage.
as the inquiry and the investigation.
This is inquiry. No, Your Lordship. It is inquiry, investigation, everything done. Now is in inquiry stage.
And since he submits that since the matter is under inquiry stage,
Before the learned special court.
before the special court, come on, the new act, the provision of CRPC
Yes, Your Lordship.
under 482.
Yes, Your Lord.
CRPC.
Your
shall
Lord.
apply
Yes, 531 of 531 of the saving clause.
in view of the
Save the-
saving clause. in the provided under section 531.
1A, 2, A.
531, 2A of
Yes.
BNSS 2020. Yes.
Therefore, it has to be filed under CRPC.
That website.
Yes, Your Lordship.
That website.
And last, Your Lordship, I would like to read out the 528 provision of the Sanghita, that is the inherent power, Your Lordship.
Okay, we'll consider that.
Okay.
I've heard you yesterday.
Okay.
Right.
Yes.
So in this particular case, since the inquiry is pending,
Inquiry is pending.
any application,
Arising.
let us not have that kind of, I would not say misconception. Maybe your understanding and my understanding, this court understanding may be different. Why not interfering with the inquiry, which will be taken by the trial court,
Yes.
special court?
Yes, Your
Will
Lordship.
be under the order. This is an application
Yes, Your Lordship.
challenging that.
Yes, Your Lordship. What I am trying.
This application or any application in the pending inquiry is a two different thing.
Yes, Your Lordship. What I'm trying to point out, if Your Lordship allow, the main proceeding is governed under CRPC. If any person is aggrieved out of it, then they have to invoke the CRPC. That is my submission, even after implementation of the new code. That is my submission, Your Lordship.
This saving clause cannot be read as if it is saves the repeal provision for all time to come. This is something to tie up the transition.
Yes, exactly, Your Lordship.
In that case, see, hypothetically,
Yes.
if the trial takes, all right, for 10 years, are you saying that all the new provisions will not be applicable because of the saving clause? The intent and purpose of the saving clause has to be seen. Of course, I'll be dealing with it.
Yes, Your Lordship.
And I request the learned counsel to bear with me, bear with this court, I mean, bear with this court for some time.
Yes, Your Lordship.
Because it is something, a stage we need to, clarify. We understand for bail application, especially anticipated bail application, pre-arrest bail, they'll suffer for a few days, but then can't help it out. Anyway, I'll record whatever you have submitted yesterday. But at the same time, can you have a different view
From
as a
PP.
lawyer, but
Yes.
as a PP?
Yes, Your Lordship. But so far as law is concerned, Your Lordship, we can
That's
make
why
a.
I have indicated.
So far as law
We'll
is.
decide your disagreement.
Yes, Your Lordship. Yes.
For court, we have.
So far as the.
For your disagreement with your PP and other learned friend, who will decide?
Your Lordship, because just my learned, with all due respect to my learned brother, Your Lordship, he
Of
said.
course, he has not gone into that
Yes.
about the inquiry.
Golden rule of.
He's only simply on the
Golden rule of
application
interpretation.
of bail applications.
And Your Lordship, he has indicated the golden rule of interpretation. If it is not in fact clear, that is the reason why this matter, every matter has been come up before this honorable court, whether new section has to be invoked or from the new code or the old section. This is
Okay.
that much, Your Lordship.
Anything else?
And Your Lordship may kindly consider section 4, Your Lordship.
Section 4, I think, prima facie, total misconception.
Your Lordship, is to section 4, if Your Lordship allow. Section 4 says the applicability of the BNSS on BNS and all other offences. And Your Lordship, interestingly, the bench of this Punjab and Haryana High Court, which is almost same view of this honorable bench, that it has to be with the BNSS if it is after implementation of the new code. Even that court, Your Lordship, has reflected that under no stretch of imagination, section 4 will cover IPC. It says that is on record, Your Lordship. It is a judge order, Your Lordship. It's all the view was different, but only to extent of that observation, Your Lordship.
But Punjab and High Court has said the mischief rule, Heron's rule will apply.
Yes, Your Lordship. And Heron's rule, Your Lordship, so far as if we see the provisions of both the code, Your Lordship,
There is no any mischief with each other, Your Lordship. In fact, the Parliament.
Substance, I'm in agreement with the Bombay and the Punjab and Haryana. Not the Rajasthan and
Yes.
coordinate bench with due respect.
See, Your Lordship, as Your Lordship yesterday has pointed out, no need to go to the other aspect. But Your Lordship, while dealing with all these aspects, Your Lordship, now this Honorable Court is dealing with the filing of the application of anticipatory bail.
In fact, I'll not be my view will not be binding now.
Yes.
Because I may have I'm only having a disagreement.
Yes.
Reason.
Yes.
But that will be settled by the larger bench.
Yes. And I'm assisting Your Lordship that Your Lordship, now it's bail 482 application. Now, one more issue, Your Lordship, is regarding the two parallel proceedings. Normally, the remedy for the aggrieved person is either FIR, and for non-cognizable offenses, Your Lordship allow. That is the complaint. In complaint, there is a substantial change in the provision.
After the
Yes, Your Lordship.
After the coming into force, if new offense, I mean, if you are alleging offense, any complaint, inquiry, it will be, there cannot be any confusion.
No, yes, Your Lordship, that is the issue.
Problem is the pendency, the pending trial, inquiry and everything. And I don't see any problem or confusion also.
Yes.
Rather, we're unnecessarily making it confusing.
No, Your Lord. Yes, yes, okay.
It is bound to happen. New law will interpret to the best of our knowledge and ability. Okay.
Apply, sir.
Yes, who will start first?
Is that the wanted to start?
Yes.
In fact, to be very fair, I'm pretty confused about this.
No, you take your own stand, whatever you understand. That is where the veteran lawyers are being requested for assistance. Even if everyone does have their own, but we'll have to try to be consistent. Yes.
If my lordship has already gone through the Punjab and Haryana court, the judgment, I'm not going to refer on that.
No, you say whatever you want to say.
No. Your lordship must be referring to that judgment dated 11/7/24.
Punjab.
Yes. Punjab and Haryana. XXX versus State of UT Chandigarh and another. Is it that case?
Yes. Justice Goyal.
Yes.
Yes.
Basically, what the court has said is that parties do not have a right to procedure. Number one. Number two, there is an interpretation of section 4(2). Then golden rule of interpretation, saying that it is BNSS is to curb the delay. Then it is the saving clause is only with regard to pending appeals, pending appeals application, etc.
Yes.
So a very detailed explanation has been given from para 8 onwards.
Yeah.
So I will not, I think, read that, since your lordship already knows this. What I will say is that lordship, in a recent judgment by the Bombay High Court at Goa bench, has your lordship seen that?
Yes.
In that case, what happened is the Honorable Court said that so far as, because the FIR was lodged before 17/24, so far as the trial, investigation is concerned, then CRPC would apply. in view of the saving clause provisions. But so far as the bail is concerned, because it was filed after it was filed on 6/7/24, so the BNSS would apply. In sum and substance, what the court has said is only that, stressing on the word pending, because it is an independent application, independent of the investigation. So therefore, it is to be filed under BNSS. Then Lordship also must have seen the Kerala High Court order.
Yes.
What the Kerala High Court has relied on this Triple X case and has relied on Hiralal's case, has not referred to Hiralal's case, and also relied on Hitendra Vishnu case. I would like to, Lordship, read the Hitendra Vishnu case, Lordship, which is reported in 1994 for SSC.
Yes.
More specific, this was the case with regard to the amendment in cases of TADA. In para 26, page number 602, 1994 for SSC 602,
Yes.
para 26. The designated court has held that the amendment would operate retrospectively and apply to pending cases in which investigations was not complete as on the date in which amendment came into force, and the challan had not till then been filed in the court. From the law settled by this court in various cases, the illustrative though not exhaustive principles emerge with the ambit and scope of our amending act, and its retrospective appropriation may be called out as follows. A statute which affects the substantive rights is presumed to be prospective in operation unless made retrospective, either expressly or by necessary intendment, whereas a statute which merely affects the procedure unless the construction is textually impossible is presumed to be retrospective in its application, should govern an extended meaning and should be strictly confined to its clearly defined limits. Law relating to forum and limitation is procedural nature, whereas law relating to right of action and right of appeal, even though remedial, is substantive in nature. Every litigant has a vested right in substantive law, but no such right exists in procedural law. A procedural statute should not, generally speaking, be applied retrospectively, where the result would be to create new disliabilities or obligations, or to impose new duties in respect of the transactions already accomplished. A statute which not only changes the procedure but creates new rights and liabilities shall be considered to be prospective in operation unless otherwise provided either expressly or by necessary implication. So basically what they have said is that a procedural law can be retrospective usually, but if it affects the substantive right, then it may not be. So one important case to be seen is the judgment of the full bench of the Gujarat High Court, which my learned friend was relying on. In this Hiralal Nansa case, if you lordship has seen Hiralal Nansa, I have a copy otherwise.
Yes.
In this case, what happened is that this is relating to the old CRPC 1898, which was repealed, and similar saving clause was there in 484. With regard to this, what happened is that under the old court, there was a provision for appeal. The forum was also different. And under the new court that is 1973 at that time, there was the forum was different. Then order of sentence in the under the old code, appeal could lie in the before the presidency magistrate if the person is sentenced to imprisonment or a fine exceeding rupees 2,000. Whereas under the new code, that is 1973, appeal would lie if the magistrate sentences a person to only if the magistrate passes an order sentencing imprisonment exceeding 3 years. So there was a difference there. Then there was a broader right of appeal in the old code, because under the old code, the High Court was one of the forum for appeal. So in that situation, the Gujarat High Court had held that because there was a substantive right of appeal under the old code, so therefore because appeal is considered to be a continuation of the proceedings, so therefore the appeal should be governed by under the old code. What I'm trying to say here is that even though there was a question of procedure, even though it could have been retrospective, the new act could have been retrospective, it was not made so because there was a substantive right of appeal which was taken away by the new act. So that may be important that may be relevant for the purpose of this case, because what happens is that is a lordship going to?
Yes.
So basically,
What's the relevant para?
lordship? No, I'm take lordship, that para would be para 4, last portion of para 4. The facts are also there. This was a then the last page. It is thus obvious that on the date when the new court, that is the last page, lordship.
Yes.
It is thus obvious that on the date when the new court came into force, the court had already taken cognizance of the prosecution against the accused, and it is from that date that the accused had acquired the right to appeal to the High Court. The accused had acquired on August 25, 1973, the right of appeal under the provisions of the old code to the High Court, and that being so, the appeal by the accused against their order of the conviction can be filed only in the High Court, and the High Court alone has a jurisdiction to entertain and dispose of the same. What I'm trying to say here is, lordship, even though it was a matter of procedure, there was a change in procedure. Then also, because there was a substantive right, and that substantive right was in the sense that there was a broader forum for appeal, which was taken away by the 1973. So in view of the General Process Act also, because substantive right is being affected, so therefore this judgment was passed basing on that. It is not that big. What I'm trying to say is, if there is a substantive right, even if it is a procedure, then and then only it may not be met. The new act may not be met retrospective. But otherwise, the literal interpretation, your lordship knows very well, that everything has been clearly spelled out. If the legislature intended that the proceeding, because a case is being filed on a certain point, starting from there till the completion of the trial, if the legislature intended that it should be under the All Act, if that the saving clause should save that, in that case, the words used would be different. There would not be a separate word used for appeal, application, inquiry, and all this. These words have to read, the word pending has to be read conjunctively with these provisions. Otherwise, it cannot be that, just like the Rajasthan High Court has said, just because the criminal proceeding starts with the FIR, so therefore everything has to come through that. If it is so, then the legislature would not have used this word separately. They could have simply used the word criminal proceedings or criminal case after with the words pending. So in my humble submission, the saving clause indicates only specific application at specific point of time. So that means if there is a specific application, that specific application, the word pending would be with regard to that only, that application and that application alone. And Your Lordship, as I have already stated earlier, that in the matters of procedure, just because something I have not brought the citation, but in AR 1953, 394, already held that trial under a procedure is different. If a trial under a procedure is obtained is different from at the time of commission of offense, that cannot ipso facto be held to be unconstitutional, which means just because procedures are used in a trial are different from those which are in place at the time when the crime was committed, it doesn't make it automatically that the trial is unconstitutional or illegal. And also yesterday, I remember there was a reference to the proviso in the ending part of 531 as making it
So,
to
that proviso is with respect to 484 in the earlier.
Yes. I would like
Earlier saving clause of CRPC
yes.
or
No,
IPC.
there was a mention saying that because that proviso is not here, so it has been done with a purpose. I don't think that argument is at all tenable because that proviso in 1973, that was given because chapter 18, which was already omitted in 1972. Chapter 18, if your lordship will recall, was an inquiry met, a power of inquiry met for before committal proceedings by the High Court and the Sessions Court. So that was taken away. That was already omitted in before the 1973 came into being. So this is of no use in this case. So therefore, this cannot obviously be there. So that is my humble submission, in short. I had brought the citation, but since your lordship has seen already, I'm not going to read it out. Oblige.
Continue at 2. I will take 5. Yes. Ah. We will confine to the bail applications and criminal petitions. Criminal petition include. It has to be. The what?
That since they have
What
said
according
trial,
to what-
inquiry,
What according to what rule of interpretation should apply? It's a literal interpretation.
literal it appears, literal appears. Earlier, the confusion was with me because it said trial.
Yes.
So I was including inquiry or investigation. So I was under the conception or misconception that this will go on by invoking CRPC and thereafter BNS. So maybe since the appeal is a continuation of trial,
Yes.
but since we are not concerned with that, and since they have specified specifically appeals, applications, trials, inquiry or investigation pending. So it
See,
appears to me
the appeal, trial, inquiry and
or
investigation
pending.
pending.
Yes.
So when audit proposed, I'm not concerned about these three.
Yes.
According to me, this appeal, trial, inquiry, or investigation, it is pending.
Yes.
Even the application, there's no question.
It appears-
Immediately before,
Yes.
it says, notwithstanding such repeal, if immediately before the date
Yes.
on which this comes into force.
Yes.
There's no issue. It has to
It
be
appears-
will apply it in the literal
Yes.
meaning.
Appears. Yes.
I find no ambiguity.
So this specific mentioned things will have to be pending only
Yes.
then.
We'll have
CRPC
to show that
contribute, yes.
it is
Yes,
pending.
yes. So since the bail application will be a new application,
Yes,
so it appears.
it's a more of a form
Yes. Form.
because
Because especially,
subject to, I mean, I'll look into it again. I read some of the judgment of the other High Court.
yes.
It's perimeter here.
Yes.
438 and 482.
Yes.
It's perimeter
Perimeter.
here. It's a matter of a form than the contents, in fact.
I was confused yesterday because section 200 and this corresponding section is totally different. The manner in which cognizance has to be taken. But now I'm veering towards, even if supposing the cause of action, say non-cognizable case,
Yes.
occurred before coming into force of this act.
Yes.
But if the implication is filed now, a complaint is filed now, then it will have to be under the new act. It appears.
So that way, I
That is
just
how I-
indicated yesterday to Mr. Ratte that in case if something comes up tomorrow, any consideration in view of this saving clause, if inquiry or the trial or investigation or for that matter any application pending
Pending.
before coming into, if it is not done as per, even if it was pending, then we'll consider. So the moment I read this judgment of Rajasthan High Court and the coordinate bench, and I just glanced to it, I was on literal sense that it is, according to me, it is not.
Yes, it appears. So
not
literal
that-
construction also it appears. that
Yes.
The application will have to be finalized.
Okay, then without loss of time, we'll place
Yes,
it
madam.
before the Chief Justice.
Yes, I was, because yesterday, I'm more worried about the pending application.
Yes,
The people's liberty are at stake.
yes. What is to be done?
But if I may just suggest, because whichever provision, madam, either under the old code or the new code, that power is already there. So, madam, these applications should be, madam, because I have not printed it out. What I have seen, Mr. Rath has given me, even in the Supreme Court, after July, the 23rd order I have seen, they are using the old section 439 also, and the new section in a bracket, and they are disposing it. So in fact, I intend to file an application today, inserting both the sections, because that is inherent in your lordship, whichever code is applicable.
The problem is now, procedurally, since this is a clear finding of the coordinate bench, that it should be under 438, not the new act. If I differ and if I had a disagreement, it has to be placed before the chief. Chief will take a call. I'll make an observation in view of so as to avoid sufferance of the litigants.
That is
Lordship
that
may
is the
take
bigger
a
issue.
call.
Ultimately, this is regarding a provision of a act, whichever section. As far as we are concerned, of course, there needs to be clarity on this. But if persons who are especially in jail, they should not suffer. Even 438 also because they are maybe wrong education.
At times I feel in between, I should not have ventured into such thing because it will have it will affect the litigants.
In any case, it appears now because there are conflicting decisions of the different honorable high courts. Ultimately, we'll have to go to the Supreme Court.
Yes. Before we ventured into, had it been placed before the Supreme Court, matter would have been better.
Better. Now the Supreme Court is taking the easy way out. They are, writing both the sections in the orders. I will place it tomorrow.
That's why I've seen in some applications,
Yes.
they've mentioned both.
Yes.
Earlier, so and so,
Earlier
so and
also.
so.
And
Maybe-
in the bracket BNSS, 483 BNSS.
Okay. Therefore, what we'll do is, I'll try to finish it today, but so that things can be placed by tomorrow before the chief. We'll have to be here for few days. I think most probably by Monday, the chief will take a call.
My lord, may make a request, my lord, that since all these applications given to them, personal liberty is stake.
Yes. Then they will observe and indicate that interim. In the interim, something can be done.
Something has to be done, Lordship.
By hopefully let us, I'll try that.
Yes.
Should be placed today evening.
Yes.
So that by tomorrow or by Monday, the larger bench or the division bench is taken up.
Yes. At least for our court, my lord.
Yes. No, it's for everybody because it will have a.
Now, our court means the Guwahati High Court, Lordship, because otherwise.
Now, having deferred the view of the coordinate bench, I cannot take up it again. Because that will apply.
Yes.
As he said. And they're just deferring.
Yes.
That the law will hold.
Yes.
And at the same time, I cannot take it up. After deferring.
If some honorable judges was here next week, then maybe in terms of the earlier filings,
Yes.
we could have proceeded with them.
Okay.
All right.
He has to continue. Burman has to continue. Anyway, you just give it to a Burman, huh? Heard Mr. All you recorded. Fee Tapo Learned Council for the
In item 4.
applicant in item 4, huh? Then who else are there? G Talo in item 5 and 6, right? And L P Gogoi, item 3, chronologically you write that. Then D Sokia, item 7, and T.Y. Bhutia in item 8. Then learned PP, J. PP, additional PP. Theater and Gitado, additional PP.
I mean, item 3 and 7.
Gitado and Arsekia, then learned advocate general. Arsekia, there is counsel, Deepangin, and Dangen, amicus curiae. Right. Yes, but helpless. Bear with us for some days, few days. All right.
Item number 3, Lordship, in item number 3, Lordship, tomorrow I may not be here, Lordship.
No, not tomorrow. This will go to the, I'll just, I differ with the judgment of the view taken by the coordinate bench. So in that case, I'll give my reasons of disagreement, and it will be placed before the Chief Justice. Chief Justice will will constitute the DB. DB will consider. So in the order, I'll request the Chief Justice to considering the personal liberties involved, so that litigants should not suffer. Consideration may be it has to be considered immediately. All right. So you'll be notified as and when it is fixed. So I'm deferring it.
Yes, Your
I
Lordship.
have a disagreement.
Yes, Your
I'll send
Yes.
further match. All right.
Deeply obliged.
प्रमुख को बोल देना order वहाँ पास. This is same
Yes, Your Lordship.
482.
Yes, Your Lordship.
You add that in that. This will also go along with that.
Your Lordship, there is urgency in my case.
Everyone, yours is washing.
Yes, Your Lordship.
There is a anticipatory bail application. We are helpless.
Your Lordship, my prayer is that,
This court is helpless.
Your Lordship, regarding the sections, maintenance of the sections, it will be hard on the next date. But since tomorrow is my appearance day, at least the interim. Your Lordship, in that case, regarding the discussions we had been having earlier, may I give one point on that point?
Huh?
I'd like to give one argument on the point of this 482. If Your Lordship permits, Your Lordship.
No, no.
Regarding whether it should be under 531 or under 482,
Hmm.
if Your Lordship permits, I'd like to give one
What?
submission.
What submission?
Your Lordship, if we look at this, the mere grammatical or literal meaning, it appears that any new application has to be filed under 531. But Your Lordship, we cannot go simply for the mere grammatical or technical meaning. Now, if we go into the in-depth explanation, it says trial or inquiry. Now, Your Lordship, when any new application is filed, we call for the records, which means calling for the record is part of the trial or inquiry. Because trial or inquiry, though these are two words, but they are of the similar meaning. So even though the application is new, but the calling for the records is part of the trial and inquiry. So it has to go under the 482 of the CRPC. It is.
You're right, you add that, but this will go along with that. Mr. In criminal petition 1116 AP 2024. Mr. The application is filed under section 482 of CRPC 1970. Now repeat. For quashing of FIR dated 28/10/2012. For quashing of GR case number 430, criminal proceeding of GR case number 430 of 2012 under section 420 pending before the Chief Judicial Magistrate, UPR. Which has been filed on today, 07/08/2024. Mr. K. Taja,
Yes, Your Lordship.
learned counsel for the petitioner, submits that since the case was registered on 28/10/2012, before coming into force of the BNS 2023 as well as BNSS 2023. The present application under section 482 of CRPC 1970 now repeal, bracket comma, bracket, is maintainable as the saving clause provides that any inquiry or trial, any inquiry and the trial, any inquiry and trial
Yes, Your Lordship.
pending before coming into force of the BNSS 2023 shall continue to be under the old act, under the
CRPC.
are saved, sorry, saved. That's all.
Your Lordship, I'd like to point something.
It's
Here,
okay, we have heard you enough.
no, Your Lordship, execution is not a trial. This is execution proceeding. This is requesting for execution.
Huh?
Execution proceeding. Execution is not a, it's a separate proceeding. Here it is mentioned that inquiry, trial, appeal, applications,
This is for execution of what?
No, no, this is for quashing of the FIR. 482.
quashing of the execution proceeding, where execution award was already
No.
first.
This is this 420 trial,
Yes,
under 420 trial for
Port-
quashing of that.
trial already concluded.
Concluded.
Yes, execution award was also passed
No,
in
Your
this case.
Lordship, the landed PP is being confused. Regarding the same transaction, one money suit is going on.
Execution is something in the money suit.
Yes.
He relies
This
upon
is-
the Supreme Court judgment of the execution proceeding.
It appears that the learned resale PP is totally confused.
No, it's not.
Submission rejected. All right.
Of license.
Yes.
Steps were taken upon the respondent then, madam. This is a second appeal, madam.
Yes.
Service has been affected upon the respondent, but they are not appearing, madam. My lord, my humble prayer is that since in second appeal, we need to frame substantial question of law.
Yes.
A week time may be given so that I can assist this court.
Okay. Service report in respect of all the respondents. A service in respect of respondents are complete.
Complete.
Mr. Dubey.
Dubey, K. Dubey.
Learned counsel for the petitioner submits that. Have you submit the
Draft issues.
substantial question of
No, madam.
draft?
I will submit, madam.
Granted a week file, submit draft substantial question of law. List after a week.
Highly ordered.
You're supposed to file additional affidavit
We filed this morning.
this morning.
This morning.
Where it is? What is the additional affidavit?
Worship, it is an additional agreement between petitioner number 1 and 3. Initially, we had annexed petition agreement between petitioner number 1 and 2. So by this agreement, Worship, all the parties, all the agreements are on record, Worship, between the petitioners.
The first, the agreement was in between.
Petitioner number 1 and 2. We have craved leave to produce a written agreement between petitioner number 1 and 3.
1 and 3.
Yes, so through this additional affidavit, we have brought on record the agreement between 1 and 3. Petitioner number 1 and 3.
It will be petition number 2 and 3.
Between 1 and 3.
1 and 3.
1 and 3.
And already there is a agreement between 1 and
2.
1 and 2.
1 and 2.
Complainant and the
Complainant and the accused person, and now complainant and the victim.
complainant and the
And the victim.
victim.
Yes, because the complaint was lodged by someone else.
Okay. What is this? What is the agreement?
Agreement is basically, Lordship, that they have amicably settled and they are willing to, that the victim has no objection regarding if the matter is quashed by this honorable court. They are family members.
Charges frame under 419,
419,
only 419.
only 419.
But 419 compoundable lawsuit. Compoundable lawsuit.
Compoundable.
Yes, lawsuit. It can be lawsuit as per the lawsuit, section lawsuit. It can be lawsuit compound by the aggrieved person before the court lawsuit.
Actually, my lord, we have made an averment in para 6 that an oral prayer was made before the learned trial court seeking for compounding the offense, but it was not allowed because this composition would be only allowed with permission of the court. So the learned trial court did not permit us to compound the offense. So here we are. We have made an averment in
Compoundable
para
with the
6
permission of the court.
with the court.
When the order on that is effect by the trial court.
As informed, Lordship, it was an oral prayer and it was considered orally.
Orally rejected.
Orally rejected, as informed, Lordship.
Where it is, where you have said?
Para 6, Lordship. Last 4 lines, Lordship.
Lawsuit, moreover, this joint petition lawsuit, as per this petition lawsuit, only lawsuit, the petitioner lawsuit, this affidavit is their lawsuit. In joint application lawsuit, both the parties affidavit should be lawsuit, together lawsuit.
See, there was an authority, I believe. It will be in the main file. It should be in the court for period.
Well, affidavit.
Pardon, Lordship.
You file an affidavit corresponding to 1 and petitioner 2 and 3. Because 2, 3 is not there. 3 has not authorized you.
Lordship, there should have been an authority, Lordship.
Huh? Okay.
2 authorities and 1 affidavit.
Authorities are there. What do you say?
If it is their lawsuit, then lawsuit, as per the lawsuit, the procedural lawsuit, this is already compoundable lawsuit. Then for compoundable
No, it's
lawsuit, inherent power, it is their lawsuit.
on the permission of the
Lawsuit,
court only.
lawsuit, it is their
Court
lawsuit.
has already,
Lawsuit. Then if lawsuit is satisfied, then it can be disposed of lawsuit.
no, it's not a question of my satisfaction. What about you? What do you
Lawsuit.
say?
Lawsuit, I have only two lawsuit, ground lawsuit. One is petitioner, as per the petition, I have not seen this other two affidavits lawsuit. And moreover, lawsuit, this
Forget about technical.
lawsuit,
Authority is there.
lawsuit. If it is private in nature, then it can be lawsuit, but otherwise lawsuit, allegation is something serious lawsuit. If
What serious?
lawsuit, because lawsuit, the
Impersonation.
that's less lawsuit. But although lawsuit, both the parties,
So what
they,
is the status now?
it is in trial stage lawsuit, they have been
No.
lawsuit.
Are you saying you have not impersonated?
Lordship.
Are you saying you have not impersonated?
Lordship, we are saying that it has been settled, Lordship, that
No, forget about the settlement.
yes, Lordship.
Have you impersonated or have you not?
That would be as of now, Lordship, on the material, the court has found that impersonation is there, materials are there. Court has the materials for framing of charge under 419, but Lordship, it is compoundable in nature. We are coming here, Lordship.
It's okay. if privacy, if you have impersonated,
Yes, Lordship.
with the question of your agreement,
Lordship, the question being that, Lordship, had it been on merit, Lordship, then had it been on merit, Lordship, we could have. But now what we are requesting this honorable court is that our settlement, the person who has impersonated the petition number 3, who is alleged to be impersonated, has agreed that she does not have any grievance towards me. Now 320 provides that it can be compounded provided with permission of the court.
suppose
Yes, Lordship.
you are Jitalo. Hmm?
Yes.
You are a promising lawyer. Can somebody come and, can Mr. Theatre
Lordship. Yes, sir.
can act like you?
Lordship, that being there, that's why, Lordship, we are invoking section 482. If, Lordship, supposing even if some wrong is committed, Lordship, but if I found it in my heart that I can forgive that person, and then I may allow that, okay, this matter may not proceed ahead. That is why we are on a humane consideration, Lordship. We are not seeking this relief based on merit, Lordship.
See, you are still continuing the service in the name of that person whom you have at least to have impersonated.
Lordship,
Is it so?
Lordship, I believe departmental inquiry has been, I have to confirm this thing, Lordship. We have made no arguments regarding that. But if this being so, Lordship, I don't believe that I should be allowed to
Oh,
continue.
human consideration we understand.
Yes.
But
Only, Lordship, if seen within the basis of the agreement, Lordship, that two persons have agreed to not proceed further in that context, Lordship, only in that context.
had you been not continuing,
Pardon, Lordship.
had you not been continuing in the as a constable,
Yes, Lordship.
in the name of the at least whom you have impersonated,
Yes, Lordship.
you can think of it. But if you are continuing in the name of that person,
Yes, Lordship. Lordship, if this matter could be kindly passed over sometime, I can get an instruction whether she is continuing or not. I can confirm, Lordship. For some time being, Lordship. I can confirm, Lordship. If she's
we
not
cannot
continuing,
shut our eyes. When
Lordship, I may not after some. It may be taken after some. After some time. Then,
not after some time. After some time, I'll dismiss.
as soon after.
Next week we'll see. But come with clean and open,
I will proper information.
open mind, transparent. This will be, if we allow,
Yes, Lordship.
that's never be, cannot be permitted. Have you understood?
Yes, Lordship.
Appears that you are still continuing
Lordship, I will get the information.
in the name of that person whom you have been at least to have impersonated.
Lordship, that I will.
If you are working,
Yes, Lordship.
working in your own name,
Yes, Lordship.
then better is we'll allow. If you are continuing in the name of that person,
Okay, Lordship. I will get that.
because it shows,
Hmm.
in fact, apart from procedure, no trial is required. Next week.
Much
Heard Mr. G. Thalok, learned counsel for the petitioners, and also heard MS El Hagelan and additional people. It is submitted that Mr. G. Thalok has filed an additional affidavit. Not it is, no, it is said that, it is, no. Mr. G. Thalok has filed an additional affidavit on behalf of the petitioners today. List the matter next week. We'll consider next week. Find out ways and means.
Okay. Much obliged.
Whether you are, you want to be continue in the job to lose, or you want to save your life leaving the job.
Much obliged.
Yes, who is appearing? Huh?
Tabit tapak.
Wait, Mr. Tabit Tapak. Last occasion also
He
he
was not present.
remains absent. And your affidavit in his favor.
Only 35 lakhs,
Whatever, he's claiming 40 lakhs,
42 lakhs.
42 lakhs, doesn't matter. You pay 35 lakhs.
My lordship, I have to take
What is
instruction
it?
whether there is,
No, you have made a statement. It's only because.
whether fund is there or not.
Only because of fund only.
Yes, my lordship, sure.
You inform Mr. Tapak also. Non appears for the petitioner on call. It is noticed that on the last two consecutive dates also, none has represented the petitioner. MS next parent. MS K. Wangmo, London State Council, appears for respondent 1, 2, 3, and 4.
All the respondents.
Yes. Next paragraph. Filing this application, the petitioner has prayed for a direction to the respondent authorities to the direction to the respondent to pay the outstanding bill amount of rupees 42 lakhs 52,371 with interest at the rate of 12% per annum. For the remaining bills for the construction of improvement of Longding Des Bimlapur Road. The respondent authority, so this next para, by filing their affidavit, has stated that the balance amount of bill to be paid to the petitioner is rupees 35 lakhs 92,213 and not 42 lakhs 52,371. It is also stated that it has also been stated that the petitioner has already been paid rupees 61 lakhs. Consideration, having considered above, substantially, so the dispute is dispute is with respect to the difference in the balance amount to be paid to the petitioner. Essentially, the 35 lakhs 92,213 is admitted on the part of the respondents. However, since the petitioner is not represented by his counsel, a last chance is granted to list this matter after 3 weeks. Or should we dismiss? Yes. Gelsan, should we dismiss or what?
My lordship.
It's this way.
Lordship.
Should we dismiss for prosecution?
It's up to your lordship.
Let us not be so harsh. Last chance with it. Yes,
My lordship.
item?
21, my lord.
Okay. What is to be done?
This cancellation of bail, my lord. On last occasion, the learned standing council SIT was directed to get instruction whether charge
Yes.
submitted.
This is, who are you?
And the informant.
This is for cancellation.
Cancellation of bail.
So these are the MLAs and MPs.
My lordship.
So this is the
Sitting
bench
Bench,
constituted
bench
for
is
it.
there, but now most probably this is not coming before the designated bench, considering he is not the present MLA, it seems, my lord.
No, it will be otherwise also. Where is this? Registry has received a letter. Where is this letter? Anyway, this is for, we'll list after some time, huh?
My lordship.
The learned council appealing for this person in view of the is to. The charge sheet has already been filed against the in such case. Yes. Who is for SIT? Where is Jambe sitting?
Your Lordship, because of some personal emergency or he left
We'll
the.
list after 2 weeks.
My lordship.
Office note that heard Mr. So-and-so,
Thank you.
counsel for the petitioner. Office note dated 0708-2024 reflects that the service in respect, and the ID card in respect of respondent number 2 has been received back. Therefore, the service in respect of respondent number 2 is complete. Since the, this the learned special PP.
Special PP.
For within bracket, SIT is indisposed today. Let the matter be listed after 2 weeks.
My lordship.
Obliged,
Deeply
Your
obliged.
Item number 22.
My lord, I'm appearing for a private respondent here in this case. This is my first appearance, my lord. I filed my wakalatnama.
Only one respondent.
Yes, my lord. State is there.
Yes, who appears for the petitioner? Mr. K. Dubey, learned counsel for the petitioner, entrance appearance on behalf of respondent number.
My lord, private respondent, my lord.
Where is the private respondent? There is no private respondent. Pinaki Roy,
Yes, my lord. There.
where is the private respondent?
I don't have the brief, my lord.
Huh?
I don't have the brief, my lord.
There is no private respondent. This is item
22, my lord.
What is the additional affidavit? What is this additional affidavit?
I'm not aware, my lord. My lord, I have filed my wakalatnama for the respondent, but since I don't have any brief, so
Find out what is the wakalat number. There is no private respondent.
my lord. I'll verify, my
Item 32.
22.
22, huh? You have given 23, yes. You have given me 23.
I'm on
Tabat
Tabat.
No. Who is for petitioner?
I'm for the petitioner, madam.
No, this is item 23. Oh, sorry.
22.
Okay. Mr. M. Doji, learned counsel for the petitioner is present. Mr. K. Dubey, learned counsel for the petitioner submits that. Mr. K. Dubey, learned counsel has entered appearance on behalf of respondent number 2.
2 men.
A list for admission hearing after 2 weeks.
My lord.
All right.
Item number 23.
Wait, your lord.
Yes.
Sir, this is a quashing petition, my lord. I have come seeking exoneration from the case as well as, my lord, the quashment of 41A notice issued against me. My lord, on the last occasion, my lord, a specific direction was given to the state as to ascertain
He has
whether
been informed that main accused in the state has been charged and pleaded in the police Yes, whether he has been charged or not.
Lordship, first of all, Lordship, may I, Lordship, this criminal petition, Lordship, quashing, Lordship, they have, Lordship, as per their, Lordship, payer, Lordship, they have agreed with the 41A, Lordship.
Yes.
And, Lordship, as per our record, Lordship, 41A, that was issued, Lordship, way back, Lordship, to the 21, Lordship. After that, they have appeared also and they have their statement been recorded also, Lordship. Then it has already been inspected, Lordship.
Applicant file an application for quashing of notice
my
under
lord,
41.
my prayer is, my lord, exoneration from the case
How?
as
Why?
well as, my lord, vis-a-vis the quashment of 41A notice. My case
Quash,
was,
you cannot quash the 41.
my case was very limited, my lord. It ought to have been a notice under section 160, my lord, a notice to the witness, my lord. But, my lord, the moment 41A notice is issued to me, my lord, my
Are you not
status as,
accused?
I'm not
Lordship,
named in
may I,
the-
Lordship, may I read the payer portion, Lordship, page 16, Lordship.
That is why, my lord, on the
Lordship,
last occasion,
Lordship,
honorable
page
court has
16, Lordship.
directed
Lordship,
as
that's
to
why,
assert.
but Lordship, their conditions are limited only, Lordship, regarding the 41A, Lordship, notice.
That's what I'm saying. He should have been issued as a witness. Notice should have been issued as a witness.
Lordship, that's why, Lordship, yes, Lordship, that's why, Lordship, even the charge sheet has come, Lordship, and their witness, their name has been there, Lordship, as a witness. That's why that 41A was issued, Lordship.
41A, my lord, notice to the accused person, my lord.
Yeah. If he's a witness, 41 ACRPC.
Okay. Lordship, moreover, Lordship, I have a submission that this charge sheet, Lordship, this is not the original one, Lordship. It is already submitted before the court, Lordship. So I may, Lordship, pair that,
Whether
Lordship.
he has been, he or she,
He, Lordship.
Pinaki Pani.
Pinak Panirami.
Pinak. Oh.
It is a only notice to
of
appear before the
appearance.
police officer.
The person is not equal under the section 26. He has committed a crime. This is the accused only,
Accused, my lord,
not a witness.
not.
Lordship, that's why, Lordship, that time, Lordship, he was 41 age issued, it may be issued, Lordship, during investigation to anyone, Lordship. After that, Lordship,
What is the 41A notice?
My lord, you will find it at page 23.
23.
it's way back, Lordship, 33, 2023. This was issued on 30/3/2023, 1 year later, Lordship. 1 year ago, Lordship. It's the last year, Lordship.
That is why, my lord, on the last occasion, honorable court directed.
Because after
They
that, he
state
appeared,
to-
Lordship, his statement already been recorded, then Lordship, this already infectious, Lordship, this notice, Lordship, why he is still coming up with this notice under 482, Lordship?
Record.
You have complied this 41.
Already complied, sir.
And
But my lord, the
Lordship.
compliance, that is why, my lord, direction was issued to the state, my lord, whether charge sheet has been filed, sending me as an accused person in this present case, my lord, limited aspect, my lord, that order, last
Otherwise,
date's order, my
it
lord.
doesn't survive. There's
My
no
lord,
cause to be
that-
in this matter, in this petition.
Because, my lord, of this 41.
They have agreed with the proceeding lesson, then their Lordship application would have been in different course, Lordship. They have already, Lordship, their prayer limited regarding the
learned
41A
PP
only, Lordship.
Say that, my lord, charge sheet, I am not charge
Lordship,
sheeted.
I have, Lordship, tried to convince before the honorable court on last
That
occasion
is-
also, Lordship, but
No, that is, what is that? Has he been charge sheeted?
Lordship, I have received the charge, but this is not the original one,
Part
Lordship. It's
time, my
already,
lord,
it is
instruction
been
is not
already,
for-
Lordship, placed before the court, Lordship. So I have prayer that if Lordship may permit, so if
No,
Lordship
what
want to
she
say.
is saying is whether it's charge sheet or not, since he has already, your only specific prayer is to
No, it's
quashing of this,
that's why,
which
Lordship.
has already been implemented, acted upon, cannot be quashed now.
My lord, my prayer portion, my lordship may kindly.
Now, what ground, Lordship,
bear
yes,
for a
Lordship.
moment, my lord.
Now, Lordship, asking for the
That
charge sheet,
is, my
Lordship.
lordship will find at page 17. It starts from 16, my lord. Not only 41 a notice,
After
the
hearing
moment I have
parties, the
been,
lordship pleased to shape asserts issued notice under section the register under of the Indian bill hearing when one of the accused in this case and drop the FIR of the said case so far as what is the accused. That cannot be, we cannot
my lord-
exonerate like this.
the moment 41 a notice is issued against me, my lord,
Hmm.
I have been arraigned, I have been taken as an
You
accused
show
person in
us
this
where,
present case.
how you,
because-
how you cannot be, how you are not to be a suspected or an accused.
My
Why you
lordship,
should be a witness?
my lordship. My lord,
Because as per section 41, any person,
Lordship, any
my lord,
if
if
there
I
is a
kindly,
suspect and
my-
if complaint is made against,
my lord,
if during the investigation, police officer, investigating authority found that they have suspect on you.
My
So
lord.
that's why 41 was noticed.
page
already
20
been
is the
complied also,
FIR, my
Lordship.
lord. It has been filed against 3 persons, my lord.
It's
Panna,
okay.
my lordship.
It's not necessarily all the accused should be named in a FIR.
Same facts and circumstances.
During
another-
investigation,
Okay.
you are found to have committed something, transferring the amount, right?
My lordship,
So your notice 41 was issued,
issued,
right?
my lordship.
You have complied, it has been implemented, whatever is there, I don't know. That once it is complied and already complied and
is-
implemented, what's the question of
That,
quashing
that
it?
is why, my lord, this question has come up now. That, my lord, because 41A notice was issued to me, whether I am being arraigned
But
as an
Mr.
accused person, my lord, in this
We'll
particular
see, you
case.
filed a different thing.
And
different-
same facts and circumstances, my lord. Another case was filed in the Guwahati, my lord. And the Honorable Guwahati High Court has, my lord, the taking into the entire facts and circumstances, my lord, was the, my lord, FIR filed against, my lord, me. So now, my lord,
Your
only.
FIR is not against you, how can we quash?
That is why, my lord, I have not come before this honorable court seeking quashment of the FIR.
Yes.
My limited prayer is, my lord, when there is another, my lord, because 160 provision is there. The moment 41A notice is issued, my lord, 41A notice, my lord, says that if there is,
You
my
have
lord,
appeared,
I appeared, my lord.
then
But now that is why honorable court has directed the learned PP to only
if
submit on the
something,
limited.
if something is there, you may come back.
La-
We'll
la-
dismiss this.
Last order, my lordship may kindly
It's
see.
okay.
The last order.
It's all right.
Only limited,
Heard, mister?
then, my lord, I may be allowed to withdraw this petition. my lord.
Withdraw it. Because once you have, once the order is implemented,
No, my lord, that is not ordered. That was a notice.
Someone notice,
And
it has been
notice under
implemented,
41
you have complied with the notice, better ends there.
My lord, 41 and
If in any other cause which you are aggrieved, that you ought not to have been an accused or whatever, that will be different thing.
there is a honorable court's order, my lord. This honorable court's order, my lord.
Well-
My limited prayer, last occasion, my lordship has
It's a-
directed
it's a
DPP
interim order.
to only submit on the limited aspect whether
Either you
charge sheet-
withdraw or will dismiss. Up
I
to
have
you.
expressed my opinion, my lord.
You want to withdraw.
I want to withdraw, but my lord, my
With a liberty, will give you, no, liberty is also not required. It's
that is why, my lord, if the PP submits that I have not been charge sheeted because I have been informed, my
You
lord.
don't have any documents you saw that
Last
whether he
occasion
is
it
an
has come.
accused or not.
Lordship, that is
It
a
has come,
different
my
thing.
lord. I
also,
don't know
because
why
in-
learned PP is not
Lordship,
disclosing it before the
Lordship,
honorable
this
court.
is the not matter of discussion, Lordship. This
I
is
don't
petition,
understand, my
this
lord,
criminal
what is
petition
the
is a
predicament,
totally
my lord?
different aspect, Lordship.
Why this particular
can
point
Lordship, I
learned
don't-
PP is suppressing that I don't understand, my
Lordship,
lord.
I
Reason
have
behind
no
that.
personal, Lordship, no interest in this matter. I
Last-
am only,
last
Lordship,
occasion, my lord,
submitting
it was there
regarding
before
this
the
thing.
honorable court.
Lordship, this petition, Lordship. Lordship have gone through the petition, Lordship.
Forget about the maintainability, whether forget about it. I just wanted to know whether he has been charged or not.
Lordship, I have
That is
received the
limited
Lordship,
aspect,
yesterday,
my lord.
Lordship. As much as his name was there, is there, Lordship.
Charge sheet.
Lordship. But Lordship, in this petition, Lordship, I cannot.
Forget
Lordship,
if and but. What
Lordship.
I'm asking you, just reply to that.
Lordship,
Whether he has been charged or not.
Lordship, in the charge sheet, Lordship, his name is there, Lordship. About
It has been charged.
the charge sheet, Lordship, matter charge sheet, Lordship. And this is
no,
also
matter is
before
Not
the Lordship.
matter whether the petitioner has been charged or not.
His name
Any
is
charge sheet is filed against him.
Lordship, that's why, Lordship, now I have to receive the charge sheet or dated before the court, Lordship. I have to call record, Lordship, for that.
Who is stopping you for calling for that?
Lordship, because Lordship, on last occasion, Lordship,
Last occasion, you have to inform.
Lordship, even it is charge sheeted or not, Lordship.
Yes.
Lordship, that's why, Lordship, I have to call
Not
record,
only
Lordship, for
whether
that.
prima facie case or the charge sheet has been filed against the petitioner.
Lordship,
along with
that,
the main-
how can I, Lordship, Lordship,
IO will
how
say,
can,
my lord,
because,
matter
Lordship,
of
I
call,
have
my
to
lord.
call the record for that,
Only
Lordship.
matter of call to the investigating
I'll just
officer.
read the order.
Lordship.
The learned counsel for the petitioner submits that he has been informed that the main accused in the instant case has been charged sheeted. And print that information may also call for whether prima facie case was also found against the instant petitioner. And whether he has been charged sheeted along the main accused. In view of the above, learned additional PP is also to furnish the required information as noted above on the next date of listing.
Lordship,
You
that's
just
why, Lordship,
inform us.
records, Lordship, I have to
Maybe
call to the registry, Lordship. This is not the case, that, Lordship. I have to call the record, Lordship, from the
Where is
registry.
it pending?
Lordship, this court, Lordship, they have already submitted the charge sheet before the Lordship, UPI court, Lordship, before the Lordship, CGM, Lordship.
You
So I have-
cannot ask for it.
Lordship, to register, Lordship, it has to
Verbally,
be
my
called,
lord, it can
Lordship.
be done, my lord. Why I am putting
Because
it in a
usually,
dark.
usually, Lordship, we, Lordship, deal with
Madam, you
the,
are a PP.
Lordship,
When the information is called by the High Court,
Lordship,
you have a authority and responsibility.
Lordship.
You can always call for the records and information.
Then, Lordship,
You are
I'm,
not debarred.
Lordship,
But by your personal knowledge, according to you, he has been charged sheeted.
it, better has been charge sheeted, Lordship, whether his name is
We
there
are
or
not
not,
asking about the matter.
Lordship.
We are asking about whether the petitioner has been charged sheeted or not.
That's why, Lordship, I have no idea because I have
Yes.
not received that order, Lordship, the charge sheet copy, Lordship. In that only we can after look
So
into
we'll
the Lordship.
all the trial court record in some other proceedings. We'll dismiss this writ petition.
My lord, my limited prayer, my lord. Because, my lord, I don't know, my lord, what is the predicament in placing, my lord, fairly I am submitting and the learned. Lord,
Fairly,
she is the
Lordship, I
officer
am
of the
submitting,
state.
Lordship.
Oh, that's, you may be correct. But so far as the merit
Yeah,
of
only
this,
compliance of the order of
merit of this matter is concerned, petition is concerned,
No case,
there's
Lordship.
nothing.
Compliance of the, my lord, order, limited, my lord. My lordship may kindly say, compliance of the order of this honorable court, my lord. The learned PP ought to have submitted, my lord, limited, only limited whether I have been sent up for trial or not sent up for trial, my lord.
For that,
If sent up
Lordship
for
has
trial,
to,
that is the end of the story. Nothing remains, my lord.
then call for record, Lordship.
Tomorrow, you call the information.
Lordship.
We'll take it up tomorrow.
Lordship.
Oh, sure. Heard Mr. So and so.
Thank you.
Then Lordship, LCR record may be called for, Lordship, then.
I also had MS L. Hage, learned counsel for the learned additional PP for the state. This court on 26/07/2024 has directed the learned additional PP to furnish the required information as to whether the petitioner, whether there is any privacy case made out against the present petitioner, and as to whether he has been charged sheeted along with the main accused. Mr. However, today, learned additional PP expressed her inability, has expressed that the required information could not be procured. Therefore, press for listing the matter the next day, listing the matter tomorrow.
My lord,
Mr.
I have applied for the certified copy, my lord. Tomorrow, preferably, I'll get it, my lord. Can it be on Monday, my lord, so that I can also place it before the number court in case the learned.
But we're dismissing it.
My lordship, under that circumstances, I'm obliged, my lord, whatever my lordship decides, my lord. Can it be
This
on Monday, my lord?
criminal petition is a different aspect,
Monday.
lordship.
Then press for listing the matter on Monday.
Monday,
is
my
what?
lordship.
11,
My lordship.
11/08, 11, no, 12,
12, my-
12/08/2024. Mr. On the next day, learned additional public prosecutor to furnish the information as directed. Mr. It is submitted by the learned counsel for the petition, next para, that he has applied for
My
the
lordship.
copy of the charge sheet.
My lordship.
He may also place the relevant, produce the relevant
Deeply obliged.
documents. He may also produce the a copy of the charge sheet. If he may also produce a copy of the charge sheet on the next day. So you can call for the information.
Lordship, I am just lordship one. I'm confused, lordship, and what next any question, lordship, what the
Next,
lordship has passed.
MSL
lordship.
London initial PP strenuously argues that on the face of the present
Petition, lordship.
petition,
No.
the present petitioner, no case is made out
Lordship.
for interpreters as the
Interpret, yes, lordship.
challenge is to the
Limited,
under section
lordship,
41A of CRPC,
lordship,
And
which has already been implemented as
lordship.
the petitioner has complied with the said
Lordship.
notice.
on Monday.
Mr.
Deeply obliged.
Having considered the merit of the petitioner, the petition shall be considered on the next day.
Lordship.
Deeply obliged.
Obliged, lordship.
I is for the petitions hearing order passed by Dishonorable Court lordship.
Why?
And this is said lordship since the parties are appearing.
Hmm.
A notice will be issued and matter fixed on 22nd.
You are appearing as a private,
I'm for the private respondent in the
not as a,
civil division.
not as a senior
not as
government
a-
lawyer. What,
It lordship see the page.
now, did you get time to appear for the?
No, this is
Right.
since it's before Dishonorable Court.
Had Mr. Estafin, Learned Counsel for the petition,
This is
by
big
filing
case.
this application, applicant. The applicant has sought for vacation, modification, alteration of the order dated 01/07/2020 passed in WPC, CRP, December
CRP.
26 of 2024. Issue notice returnable by 3 weeks.
22nd. We have
22nd.
consent.
Why?
22nd.
Why 22nd?
Lordship, early disposal, the
Okay.
entire matter can be.
Returnable by 22/08/2022.
In the meantime,
24. Mr. As Mr. K. Lawland, Learned Counsel for the Learned Counsel appears, entered appearance and accepted notice on behalf of
1 and 2.
opposite party.
1 and 2.
1 and 2,
And 3 and 4, my friend.
and Mr.
Modi.
O Modi for respondent 3 and 4. No
Copies,
further notice.
copies have been
Yes,
served.
sir. How about the learned counsel for the petition applicant to furnish copies
Copies already furnished.
if not already furnished. List
And
the
objections, if any, they have to file.
matter. In the meantime, list the matter on 26 presidential. In the meantime, parties may exchange the affidavit. But parties may file objection. Opposite parties may file objection.
And let's say in main case,
In main case, list the matter
yes,
on 24 so and so.
and yes, there is an interim order.
Interim order was the earlier shall continue. Yes. We allowed this to be listed for orders. Why hearing?
Well, in fact, as per the record, it is in
Yes,
final.
I've heard, you have submitted that, so, but then we thought we'll list it for orders or to fix the date. Yes,
Malad, may I phrase it, Malad, at this stage, Malad, matter will be disposed of only, Malad, the aspect is the interlocutory order passed by the landed court below has been challenged under this route, this criminal revision petition. Now, at that relevant point of time, the matter was under investigation. Now, the investigation process is, everything is done, Malad. If anything is found against me, Malad, definitely, Malad, the landed court below will, Malad, impose the cost, even, Malad, the amount which has been decreased and that has been withdrawn by me, Malad, that will be definitely, Malad, taken into consideration by the landed court.
you are for?
I am for the private respondent, Malad, only because of dependency of this two connected Malad, the revision petition, Malad, I am suffered.
Private respondent.
Malad.
Who is for the petitioner?
I am for the petitioner in lawsuit, item 26 lawsuit.
Then this
And state is one of the, Malad, the revision petitioner.
and
Third one, Ranjit is, Malad, only pendency of these two connected Malad, criminal petition, Malad. The landed court below is of the opinion that since matter is already pending before this honorable court, so therefore, Malad, the landed court below declined to take up my case, Malad, saying that, Malad, the similar connected matter is already sub judice before this honorable court.
who is you are accused?
Yes, Malad. And Malad, I have given undertaking, Malad.
Yes, it's of 2016. What had happened now by now?
Now, Lordship, charge sheet has already been filed
Yes.
before the trial court.
Hmm.
Now, that is different aspect, but what we are challenging, what I am challenging before this, by this application, Lordship, is the order passed by the magistrate, thereby defreezing the account that has been seized by the police during course of investigation, and the amount that has been clearly objected by from the SIT, saying that the amount is an involved amount that has been misappropriated. That amount was in fact my bill, which was sanctioned against my firm, that has been fraudulently withdrawn by the driver of the accused person, and during that period, the amount of 5 crore has been transferred in this account.
Where is that impugn order?
Impugn order, Lordship, at
Annexure 86, Malad, page number 86, Malad.
it's not from 86.
Annexure 12 series, Malad. Relevant is, Malad, page number 90. 91.
Page 90, Lordship, operative portion.
He has executed a bond.
My lord, page number 90, just previous page number, my lord, 92, my lord. 92, my lord. I sitting so and so, resident of so and so, so and so. In present case, I took a sum of so and so amount only in account number so and so, which was seized by Nahalagan police in connections with Nahalagan police case, PS case number so and so in N SIC vigilance case number so and so. And I undertake to produce the said amount before this honorable court as and when required. And if this amount is found to be misappropriated, if I fail to produce the said amounts as mentioned in this bond, I shall be liable for the legal action as deemed fit and proper by this honorable court. So therefore, my lord, basing on this, my lord, no, my lord, we are not running away. And we are ready to face the trial also, my lord. This is not the amount which they have freezed, my lord. Altogether, the bill amount was around 26 crore, my lord. And this was the amount only freezed in my account when the amount only, my lord, is stationed in my account to the tune of, my lord, 2 crores. The total enter bill was, my lord, that 26 crores, my lord. So therefore, my lord, this is a subject matter of the trial. If I am found, my lord,
You are a party to that in the proceeding. Are you a complainant? You are a
Yes,
complainant.
complainant. FIR was lost by me. Here, Lordship, the issue also regarding the issue involved is on law point also. Well, this offense, this is under a special court. The offense is triable by the special court. But this impugn order has been passed by the judicial magistrate first class.
My lord, FIR is
Yes, so CJM, Chief Judicial Magistrate.
FIR is page number 42, not lodged by my lord, DDSC, my lord. He is somebody else, my lord.
The FIR was lodged by my agent.
Page number 44, my lord.
FIR was lodged by my agent.
Okay.
I've been authorized them to lodge the FIR because the petitioner is out of station.
Are the monies still with you or have you spent it?
My lord, after withdrawal, my lord, it has been spent.
So how you'll, when the court wants, how you'll deposit?
My lord.
How you'll deposit if the court
My lord,
requests?
as I've already pointed out, this is not the only single amount, my lord, where I've taken, my lord. This entire amount, my lord, is.
No, you have enjoyed, will direct you to deposit the seized 2 crores.
My lord,
Will dispose it of with a direction to deposit you.
my lord, as I have
Because
already.
you have
My lord, as of.
executed a bond, and
My
there's a direction. It's been 1688 almost when this order was passed.
2000.
Passed on
uh,
the
15, my
9
lord.
years.
10 years, my lord.
You deposit.
My lord, once the trials is commenced, my lord, if the amount is, my lord, found to be, my lord, misappropriated, my lord, in that
On
case,
the
my lord.
condition that he will execute a bail bond this court, that he will deposit the amount deposited in the account of before the court as and when so required.
My
Will you deposit it?
my lord, so far, my lord, it is not, my lord, established that this amount is misappropriated, my lord.
No, till disposal.
My lord, in
They
that
will
case,
remain with the court.
my lord, in that case, my lord, that is the order in, my lord, the order passed by the London court below.
Yes.
My lord, where in, my lord, once the, my lord, is, if it is found to be a misappropriated amount, my lord, definitely, my lord, this is not
See.
the only amount.
Whatever, we'll ask this amount only.
No, sir.
My lord,
This amount will ask you to
my
deposit.
lord, my lord, the freezing was only because of the, my lord,
It's
the,
okay that the magistrate has found, the London magistrate has found that it was not properly seized.
yes, my lord.
That's all.
So therefore, my
There was
lord, no is very,
aberration in the seizing of the account, freezing and whatever. But there's a condition that you'll execute a bond and as and when required. I think we'll direct you to deposit.
My lord, in that case, my lord, it will be very difficult on my part to, my lord.
You have enjoyed 9 years, 10 years,
No, my lord, in
and
fact,
it is better is yet to be
my lord, it
decided.
is not established as of now, my lord, that amount is misappropriated.
How can, unless the trial is completed, how can you say that this is not established?
My lord, trial,
You may have established, not
Madam,
established,
if-
whether you are guilty or not, that will be the matter of trial.
my lord, therefore, my lord,
But
at
in
this
the
stage-
meantime, you deposit balance of convenience. You have enjoyed 10 years.
my lord, at this stage, my lord, then in that case, my lord, may I friend it, my lord, matter may be posted for some other date. In the meantime, I'll take another, my lord, instruction from the, my lord, my client, man.
Next week.
It's because, my lord, if
Next
the,
week.
my lord, the condition is, if it is found to be an,
No, you have agreed the condition.
Yes, ma'am.
Accordingly, you have executed a
yes,
bond.
man,
And it is of 2015,
my lord.
nearly 10 years, 9 years.
My lord, pendency of 9 years is only because of the, my lord, this,
Because
criminal
prima facie, there is a prima facie case.
Yes.
Charge sheet has been filed.
Yes, ma'am.
What is the stage of trial? How many witnesses?
My lord, the report is here.
We'll send it back. I think you have rightly mentioned this matter. Just because it's pending, how can there be a? No trial cannot be stalled.
My lord, therefore, my lord, what my submission is, my lord, to make a fair submission, my lord, if once established, my lord, everything will be, my lord, that part is something,
That security we want. You will never know.
my lord, therefore, unless it is established, my
Sir,
lord,
you have
unless it is,
enjoyed for 10 years.
My
Next
lord-
week.
my lord,
Fairly, you have mentioned this matter.
my-
I didn't realize, this court didn't realize. You have fairly mentioned.
my lord,
I
only for the,
appreciate.
my lord, only for the, my lord, without, my lord, interpreting the, my lord, the order which has been impugned in this border writ petition, my lord, that matter may be sent back to, my lord, the trial court, my lord.
No, it has spent his course, and you have enjoyed.
My lord, as I have already pointed out, my lord,
But because
once
of
it
the
is established,
pendency-
my lord, once it is established, my lord, the consequences will follow like punishment and other things, my lord, even reparting of the amount, my lord. So therefore, as of now, my lord, so far it has not been yet proved.
Are you supporting the judgment of the order of impugned order? Are you supporting?
My lord, that is the,
You are supporting the impugned order
my lord,
of the London magistrate.
my lord.
We'll agree to that. Accordingly, we'll direct you to deposit. It's a time you to deposit.
My lord, before that, my lord, commencing of the trial, my lord, depositing of the amounts will again, my lord, ultimately, my lord, it is a, money, my lord. The money has to be, my lord, it cannot be kept for the, my lord, the,
No, it will be in the custody of the court.
my lord. So
Right.
therefore, my lord, at
It's
this
special
stage, my lord, that will be again prejudiced to me, my lord, by depositing the amount, my lord.
Sir,
Unless it is,
Sir, if you want to avail the order of the
then my lord,
fruits of the order,
then my lord may fix for the,
you
my
have
lord,
to enjoy it.
detailed hearing of the case, my lord.
Not
Facts are something different, my lord.
not the bits and pieces.
My lord, facts
So
are,
I said, we'll appeal the order of the learned magistrate.
my lord.
All right. We are supporting the order, and we'll say deposit
Depositing
in
part,
terms of the order of the learned magistrate.
my lord, that this is the depositing of the amount will be again, my lord, that is amounting to, my lord, I am entitled, my lord, bills are being entitled by me, my lord. The amount which has been legally withdrawn by me, that cannot be, my lord, even deposited. My lord, as I pointed out, a FIR has been launched by somebody else. And my lord, the owners are different. We have made the transactions to the rightful owner of the,
Sir, that will be the matter of trial.
my lord. So
Guilt or
therefore, my
otherwise
lord,
will be
may I
settled.
pray that, my lord,
So
matter
in
may be
the
posted for the
meantime- in
hearing,
the
final hearing,
meantime-
my lord.
So that trial can also proceed and to have a security because it's the involvement of money, misappropriation and
Therefore,
embezzlement.
my lord, it's executed,
Therefore,
bond is
you
executed.
deposit it. We're not giving it to anyone. It will be before the custody of
My
the
lord, there is
special
no,
judge.
my lord, circumstances and a prima facie case that, even if it is not deposited, my lord, trial cannot
Sir,
be
you
commenced.
fight it out there.
Trial cannot be commenced.
All this you fight out
My
there.
lord,
Now we're concerned about they are agreed by the impugned order.
my lord, as I have pointed out, this
You
is
are
not,
supporting it, will upheld it, will affirm it, but then will ask you to deposit.
Well, in that view, my lord, may I present, my lord,
You
madam?
take instruction next week.
My lord, may I please, my lord?
Yes.
My lord, the issue is very simple, madam. My lord, we were handed over the case because the SIC was investigating, madam. Earlier, the Nagaland police was investigating.
Yes.
On 2/7/2014, my lord, the case was forwarded to the SIC. And since the SIC came, started investigating, my lord, all the cases which are being investigated by the SIC are special, since it involves PC Act. The power is under the special judgment. But here, this impugn order, my lord, was,
Therefore, you have filed the, state has filed the
yes,
petition.
yes, ma'am.
Number one. Ah.
Therefore, my lord.
And why this revision petition 65? Ranjit Kumar Singh.
Therefore, my lord, it is somehow connected to the main, my lord, the principal account, my lord. This person, my lord.
So why you have who is Ranjit Kumar Singh?
My lord, he is a business.
He is also an accused.
No, my lord.
Why you have filed it?
My lord, he is he is business person.
What is this matter?
My lord,
Pertains to what?
pertains to, my lord, de-freezing of the account, same account, my lord. He is a businessman having, my lord, business based at Delhi, New Delhi, my lord. And he purchased, Mr. Ngurangaya purchased a, my lord, share bond from the company of this Ranjit Singh, owned by the, my lord, the Ranjit Singh, my lord. And he has purchased the, my lord, share.
Kindly find out, all of you. I just vaguely remember. I think I might not had any, I mean, any opinion on in this issue.
My lord, maybe yes,
Find it out.
he's
We'll
directly.
fix it next week. Find out.
My lord,
You also. I think I vaguely remember.
yes, yes. I still remember.
When you told,
yes.
when you.
It pertains
One.
to the previous case.
Yes, yes.
Yes, yes.
PL
Maybe some, I may have.
250 up to 10 form.
Yes, I might have given some opinion or something.
My
Like
lord.
that. You find it out.
And Mr. Tarko, my lord, before this school, is also my lord, had that opinion.
You find it out.
Yes.
Any idea?
No.
You find it out tomorrow. Okay. On 16th. If this code is nowhere, I mean, I'm not connection. I mean, I might have given some opinion on this issue. So, though these matters have been listed for hearing today on mention being made by Mr. M. Katat, counsel for the petitioner in criminal petition 65 of 2018 and respondent in criminal petition 3 and what is this? 3 and 3?
My lord, in 3, I am respondent number.
There are 2. Why this 2?
Criminal petition 3 of 2016, I am respondent number 2. And
Criminal petition 3 of 2016 and criminal revision petition of 2016. Yeah, as a respondent, na? And respondent, and for respondent in criminal petition 3 of 16 and criminal revision petition 16, 2016, 3 of 6 and 16. Comma. On the prayer of learned counsel for the parties and having considered the issue, the nature of issues involved in this matter, this matter on 16/08/2020. You find out if there's nothing, I mean, if I'm not given this, if this court has not given any opinion and anything on it, we'll dispose it of. You take instruction.
Deeply honest. My lord,
May I sign, my lord?
Where's the paper book? Yes.
My lord, I think only my part is left, my lord.
Yes.
Now, my lord, I will start, my lord, with pointed, my lord, the ground, my lord, and region, my lord.
Series of data. Series of data. Motion, bail application, criminal. Put it there in the file. Connection with this. Just wait. Connection with this. Print it out. Yes. You have given. Yes.
Yes, ma'am. First point, my
How
lord,
long will take?
hardly that 15 minutes, my lord.
Okay.
First point, my lord, I
Try
am
to-
making.
Try to finish by 10 minutes.
First point I am making, my lord, the ground in the region, my lord,
Yes.
argued by the learned senior council, my lord, had already been argued before the learned court below, my lord.
Yes.
Now, that had been, my lord, beautifully, my lord, answered by the learned court, trial court, my lord, with fact and law, my lord. Now, until and unless some perversity, my lord, is pointed out by the learned senior council to the judgment of the trial court, my lord, on no perversity, my lord, has been mentioned, my lord. So, that count alone, my lord, this appeal liable to dismiss, my lord. Second point, my lord, I am making, my lord, now, as my this being a statutory appeal, my lord have authority to represent the evidence, my lord. Therefore, my lord, the appreciation of the evidence, my lord,
Yes.
by this honorable court should be within, will be within the purview of the this section 29 of the POCSO Act, my lord. Now, section 29, my lord, say, my lord, the prosecution, my lord, only need to prove the foundation peg, my lord. One, it is proved by the prosecution, my lord. That has to be reversed by the accused, my lord. Now, I humbly believe, my lord, the foundation peg, my lord, of this case being duly proved by the, my lord, prosecution, my lord. If my lord have already read the deposition of the victim, my lord. Now, victim statement under 164, once and the deposition of the court, my lord, is same, my lord. Only difference, my lord, point out by the learned senior counsel, my lord, is that in the 161 statement, my lord, the victim did not say anything about, my lord, touching his private part, my lord. But even then, my lord, the kissing, my lord, kiss by the accused, my lord, to the victim, my lord, is
More than that.
I'll
Mr.
I'll try.
Burton, learned senior counsel assisted by Mr. M.U.B. learned counsel for the appellant. We also had Mr. M.S. L. Hage, learned addition PP for the state, and Mr. L. Permit for respondent number 2. Hearing concluded. Judgment reserved.
Yes.